Hi students, I am Professor Kshitij Bansal and I teach law at Jindal Global Law School. The module that we are going to discuss today is about protection and problems under international law. What will you be learning from this discussion? You will learn about the international refugee law and various legal mechanisms that are brought in place to ensure safety and security of the asylum seekers. You will also learn about various legal provisions which facilitate asylum for the asylum seekers and also to elaborate on their rights and the consequent enforcement mechanisms. Non-refoulement is a fundamental principle of the international refugee law that protects the interests of the refugees seeking protection from a state. This principle forbids the country receiving asylum seekers from returning them to their persecutors. The legal principle of non-refoulement has been defined at various regional as well as international levels. The first reference to this can be made to 1951 United Nations Convention relating to the status of refugees, by which Article 33 explicitly lays down that no contracting state shall expel or return, which is refoul, a refugee in any manner whatsoever to the frontiers of territories where his life or freedom would be threatened on account of his race, religion, nationality, or membership of a particular social group or political opinion. International refugee law is a set of rules and procedures that intrinsically aim to protect, at first, the persons seeking asylum from persecution and those recognized as refugees under relevant instruments. The main source of refugee law is notably treaty law. That is 1951 Convention relating to the status of refugees and its 1967 protocol, and then also some customary international law practices. This module would scrutinize the protections granting the refugees under these instruments, and it would also briefly comment upon some loopholes which the Convention failed to address. It would also highlight some problems in the existing Convention. Right of non-refoulement. Non-refoulement is a principle in international refugee law that prohibits handing over a victim of persecution to his or her persecutor. To understand the principle of non-refoulement, one must be familiar with the concept of persecution. The literal meaning of persecution is the systematic mistreatment of an individual or group by another individual or group. This may include inflicting of suffering, harassment, isolation, and continuous exposition to cruelty. The most common forms of persecution are on the grounds of religion, ethnicity, socio-economic backdrops, political backgrounds, etc. Though in some cases they are distinctively visible, but they usually intermingle with each other. Principle 6 under the Nuremberg Principles categorizes persecution on political, racial, or religious grounds has been categorized as a crime against humanity. Crimes against humanity have been prohibited under the ambit of international laws, and there is no tolerance that exists against them. A persecutor is an individual or a group of individuals who inflicts such crimes. Therefore, the principle of non-refoulement disallows the giving up of true victims of gross crimes against humanity to their persecutors, and it largely makes an effort to safeguard them. Article 33 of the 1951 Convention provides for prohibition of expulsion or return. No contracting state shall expel or return a refugee in a manner whatsoever to the frontiers of territories where his life or freedom would be threatened on the account of his race, religion, nationality, membership of a particular social group, or a political opinion. The benefit of the present provision may not, however, be claimed by a refugee whom there are reasonable grounds for regarding as a danger to the country of security in which he is, or who, having been convicted by a final judgment of a particularly serious crime, constitutes a danger to the community of that country. This particular provision, which I just read out, puts a restraint on the contracting state which has granted refuge to the refugees. Such a state could not force the refugee to return to the state where the atrocities of crimes against humanity would be inflicted against him. Article 33, Clause 1 basically lays a general rule whose exception is granted in Article 33, Clause 2. A refugee would fail to fall under the general mandate if reasonable and diligent grounds have been provided for. That refugee who has been convicted by final judgment for particularly a serious crime, and there is a danger that he may threaten the security of the country he has been convicted in, he could be expelled by the country he is apparently residing in, and he could not avail the benefit of the principle of non-refoulement. In regard with the application of Article 33, Clause 1, it extends to any convention refugee who is physically present in the territory of a contracting state, irrespective of whether his presence in that territory is lawful or unlawful. This article applies to persons who are prima facie refugees. In spite of the apparently all-comprising return in any manner whatsoever, it is quite clear that the drafter did not intend article to affect the question of extradition. The word refoulement is used in Belgium and France to describe a more informal way of removing a person from the territory, and also describe non-admittance in the state. This word may be applied to persons seeking admission, persons illegally present in a country, and persons admitted temporarily or conditionally. Article 33, Clause 2 does not really require a strict proof in regard with the refugees being a danger to national security. This provision applies to a refugee whom there are reasonable grounds for such a danger. The decision whether the refugee is of such a danger status is subjective to each case and must be left to the discretion of the respective state. The word danger in Clause 2 of this article comprises of danger in the present or in the future. In interpreting the term security of the country, it is deduced clearly that if a person is engaged in activities aiming at facilitating the conquest of the country where he is staying or a part of the country by another state, he is threatening the security of the former country. This termed in rather invokes against the acts of grave kind which directly or indirectly the Constitution or the government the territorial integrity, the independence, or external peace of the country concerned. It may not harm, in any circumstance, the external sovereignty of the country. Let us now talk about right to asylum. Right to asylum under the purview of international law, under which a person is persecuted by his or her own country, may be protected by another sovereign authority. Like international human rights law, modern refugee law has its origins in the aftermath of World War II, as well as refugee crisis of the interwar years that preceded it. Article 14, Clause 1 of the Universal Declaration of Human Rights, UDHR as we know it, which was adopted in the year 1948, guarantees the right to seek and enjoy asylum in other countries. Subsequent regional human rights instruments have elaborated on this right, guaranteeing the right to seek and be granted asylum in a foreign country in accordance with the legislation of the state and international conventions. The adjudication of asylum claims is reserved to individual states, although some states, namely those that comprise the Council of Europe, have made an effort to adopt a uniform asylum system. International and regional bodies lack the jurisdiction to adjudicate individual asylum claims. Though there is different enforcement mechanism to grant refuge to the citizens of other states, and they vary from one country to another, there are certain common features that exist in the domestic legal system of a particular state and are defined as follows. Refugee. State parties to the 1951 Convention or the 1967 Original Protocol have incorporated the definition of refugees as stated in Article 1 of this Convention into their domestic legal system. Second is the definition of asylum seeker. Person within a state who has applied for recognition as a refuge. If asylum seeker is determined to meet the definition of refugee, they are granted asylum by the state they have applied in. Third, race, religion, nationality. The asylum applicant need not actually possess the racial, religious, or national characteristic in question, provided that characteristic was attributed to the asylum seeker by the persecutor and is the reason for persecution. Regarding membership in a particular social group, there is still a lack of consensus as to what constitutes a particular social group and whether classes of persons not included in the 1951 Convention, who nonetheless face persecution, such as women and homosexuals, fall within this category. About war crimes and crimes against humanity, states apply the definition provided under international humanitarian law, as articulated in Articles 7 and 8 of the Rome Statute of International Criminal Court. It would now be pertinent to talk about UNHCR and its relationship with refugee protection. The Office of the United Nations High Commissioner for Refugees, also known as UN Refugee Agency or UNHCR as an abbreviation, is a United Nations agency mandated to protect and support refugees at the request of the government whose citizens are suffering the atrocities of prosecution or the UN itself. The UN would assist in their voluntary reparation, local integration, or resettlement to a third country. Its headquarters are situated in Geneva, Switzerland. This organization has worked extensively in relation with refugee protection over the years. It was established on 14th December 1950. UNHCR won the Nobel Prize for Peace twice. Its primary purpose is to safeguard the rights and well-being of refugees. It strives to ensure that everyone can exercise the right to seek asylum and find safe refuge in another state, with the option to return home voluntarily, integrate locally, or to resettle in a third country. UNHCR's activities to promote refugee protection include the following: promoting accession to the 1951 Convention relating to the status of refugees and its 1967 Protocol, accession to the 1954 Convention relating to the status of stateless persons, accession to the 1961 Convention on the reduction of statelessness. In 1999, UNHCR launched a campaign to promote accession to the 1951 Convention that culminated on its 50th anniversary in July 2001 and the ministerial meeting of state parties to the 1951 Convention on 12th and 13th December 2001. Its another function is to assist states to enact or revise national refugee legislations, including administrative instructions and operational guidelines, and to implement national refugee status determination procedures. Another important function is to strengthen relevant administrative and judicial institutions, training staff of government and non-governmental agencies, and liaising with relevant human rights bodies. We've mentioned about this convention a number of times. Let's know more about it. The Refugee Convention 1951. The 1951 CRCSR, as it is commonly called, the Convention relating to the status of refugees, is a United Nations multilateral treaty that defines who is a refugee, and it even sets the duties and rights of the individuals who are granted asylum and the responsibilities of nations who grant asylum to the displaced people. The Convention also sets forth the people who could not qualify as refugees, like war criminals. Under this Convention, a brilliant provision is set out for the refugees for visa-free travel for the holder who has a travel document under this Convention. After the adverse repercussions of World War II, this Convention was approved at a special UN conference on July 28, 1951. Before January 1, 1951, it was just limited to protect European refugees. It came into force on April 22, 1954, with provisions which were applicable universally. The 1967 Protocol removed all the geographic and time limitations in relation to this Convention. The geographical scope with respect to this amendment was increased. Denmark, on December 1952, became the first state to ratify the treaty. Till 2014, there were 145 parties to the Convention and 146 to the Protocol. Surprisingly, the United States of America is the only party to the Protocol which is not a party to the Convention. General obligations of a refugee under Article 2. The Article 2 of this Convention goes as follows. General obligations. Every refugee has duties to the country in which he finds himself, which require in particular that he conforms to its laws and regulations as well as to measures taken for maintenance of public order. Non-discrimination under Article 3 is another important feature of this convention. The contracting states shall apply the provisions of this convention to refugees without discrimination based upon race, religion, or the country of origin. Discrimination may be treated under this article as discrimination between refugees and nationals, discrimination between various classes of refugees and other aliens, or between various classes of refugees themselves. This article, which we've discussed so far, basically means to say that refugees and stateless persons authorized to reside in a country must conform to the laws in force. Every refugee benefiting from the terms of the convention must be subject to provisions of Article 2. This article only lays down an imperfect obligation. It does not provide for any sanctions in case refugees who does not fulfill his duties. Article 2 only speaks of the country in which the refugee finds himself in. Underlying this phrase is apparently the old notion of territorial allegiance. However, the phrase should not be interpreted too narrowly. A refugee may certainly also have duties towards other countries than that where he is physically present. Example, towards the country where he is lawfully staying, even if he is temporarily absent from that country. In view of the fact that refugees, being without effective nationality and without diplomatic protection, Article 2 may be read to imply that the state in whose territory a refugee finds himself may also subject him to such laws and regulations which normally would not apply to aliens. Example, rules relating to military service and discriminatory measures which are not prohibited by express provisions of the Refugee Convention. Thank you.